I'm just going to say that as far as child support is concerned, Mr. McNeil does not owe any retroactive child support. So there'll be a zero balance for that.
Tonight's case is a tug of war over retroactive child support and medical costs. Mom says dad fell short. The state ran the numbers to nearly $35,159 in back support, plus $17,136 in premiums. And dad fires back, we had a deal, $300 a month, and our daughter stayed with me part of the time. Documents, addresses, school records, and who really paid what become the battlefield. The twist? A judge who likes to honor private agreements, but only up to the law's limits. Watch closely. Small details like voter registration, school enrollment, and phone bills could swing thousands. Who's right here? The agreement, the guidelines, or the receipts?
I'll call the mother. Ma'am, will you state your name?
Wildest of all.
And what's your child's name?
Jayla McNeil.
Okay. And when Jayla was born, did Mr. McNeil sign a document admitting he's the biological father?
Yes.
Okay. And in the last 4 years, who is your child living primarily with?
Me.
Has she ever spent a majority of her time living with Mr. McNeil?
No.
Okay. And when you have enrolled her in school, specifically the last 4 years, were you using your address or the father's address?
My address, the only time was this school year in the beginning, but it changed.
We open with a stinger. No retroactive child support, zero balance, but don't blink. That's not a spoiler. It's a legal breadcrumb signaling how judges sometimes weigh long-standing private arrangements when there's no prior court order. The court still needs to test. Where did the child primarily live? Were there consistent payments? And do addresses used for school equal custody? Spoiler, often no. Keep an eye on the 4-year window the state is using and the credit mom's willing to give, $12,025. Question for you. If you privately agree to $300 but pay it inconsistently, should the court jump to the guideline amount later or stick to the original bargain?
But the last 4 years is my address.
Okay, but this senior year, you enroll her in school based on the father's address?
Yes, but she was living with me.
Objection, anything after yes.
What's your objection?
Non-responsive.
Okay, overruled.
And Ms. Stovall, how come you decided to enroll her in a school in the father's district for her senior year?
Due to having to move with my granny and trying to be able to pay for her with no assistance for school, I did have to move with my granny. So I've been, we didn't have a consistent address when it was time for school to start. So he allowed her to be able to use his address. But Jayla is still with me and my granny.
Mom explains using dad's address for senior year enrollment because of housing instability. Key point, school address primary residence. Courts look at overnights and day-to-day care, not just what's printed on a form. Mom says the child still lived with her while using dad's district. That undercuts dad's "she lived with me" theme, unless he proves actual nights and consistent care. Engagement. If you had to choose a school in a different district to keep a kid on track during a move, is that smart parenting or a custody red flag? Drop your take. Would you have done the same?
At a time, for now.
Okay. And you're requesting retroactive child support for the last 4 years, correct?
Say that again. We didn't catch your microphone.
Yes, sorry.
Okay. And was there a private agreement between you and the father regarding child support in 2023?
Yes, that was the reason why we went down there to the court and we made an agreement where he would pay $300 a month, but he's been inconsistent where why I am just now requesting retro because I was, trying to be understanding to the agreement that he didn't.
Here's the heartbeat of this case. A private 2023 agreement at $300 a month. Mom says dad was inconsistent, which is why she's now asking for retro at guideline levels. $983 a month. Legally, private deals aren't court orders unless filed and signed, but judges often consider them as equities, evidence of what the parties intended and relied on. The state totals $35,159 retro after credits. Mom agrees to the math. Your call. If one side relied on an informal deal for a year, should a judge lock in that number or recalculate using the higher statutory guidelines?
Continue doing. Should have.
Okay. And so he has paid some months of $300, and so we've calculated a total to be $12,025. Is that correct?
Correct.
Okay. And you're willing to give him credit for that, correct?
Yes, ma'am.
Okay. And based on his wages, we've calculated that child support would have been $983 each month. And after calculating the retroactive support for the last 4 years and giving him credit, the balance we came to was $35,159. Are you in agreement with that amount?
Yes.
And we've calculated a monthly payment of $226 beginning June 1st, 2025. Are you in agreement with that?
Yes.
Okay. And you're also requesting retroactive medical support, correct?
Yes.
And in the last 4 years, what kind of health insurance coverage has your child have?
She's have medical, dental, vision.
And has that been through your employer?
Yes.
Okay, so the last 4 years she's had private insurance. Is that correct?
Yes.
Okay. And you've been paying $357 per month for that coverage, is that right?
Yes, for the medical, and then the $357 was just medical. It's $357.25 for medical, and $56 dental, and $4 for vision.
Medical support is a separate lane. Mom had private insurance the whole time. $357 25-month medical plus, $56 dental plus, $4 vision, and says no reimbursements. The state clocks $17,136 over 4 years and proposes a 136-month payback. Even if a judge trims retro child support based on equities, they often enforce medical, especially when one parent carried coverage alone and the other benefited. Real-world tip: keep premium statements and payment proofs. Courts love clean paper trails. Who here did the better record keeping?
Okay. And you're requesting that the father pay you back for the 4 years that you've carried the private insurance?
Yes.
And have you, in the past 4 years, he reimbursed you for any of the premiums you've incurred?
No.
Okay. And so we've calculated a total for the medical support at $17,136. Are you in agreement with that amount?
Yes.
And we've calculated a monthly payment at $136. Are you okay with that?
Mom testifies no 50-50 split in the last 4 years. Child lived primarily with her. That's huge because retro support typically mirrors actual primary care. For dad to chip away at arrears, he needs concrete overnights data, calendars, messages, affidavits, school logs, not just addresses. Audience check. What would you accept as proof the child actually lived with dad? Driver's license address or weekly overnight logs?
Yes.
Okay. Do you have any safety concerns if your address or your phone number is in the court order?
No.
Okay. Is there anything else you want the court to know about the retroactive child and medical support issues?
Just not anything I can think of, but I do have my proof of what he's paid me and where she has lived. I do have all my records of where her whereabouts and her living arrangements and how much he's paid me and how much I've paid for insurance today.
Okay. And just to confirm, in the last 4 years, your child, you're saying, lives primarily with you?
Yes,
That you and the father did
100%.
not do a 50-50 split at any point?
No, not at
Okay.
all.
Defense tries to puncture mom's credibility. Driver's license address, voter registration, multiple residences. Mom counters that documents reflect her address, and the child never spent a night with dad. Legally, ceremonial documents can be weak evidence of residence unless backed by habitation facts. Meanwhile, mom's steady story, same place with grandmother, helps her on consistency. Strategy watch. The more the defense leans on paper addresses, the more the state will say, show us overnights. Where do you stand? Paper trails or lived reality?
Okay, I'll pass the witness.
Mr. McNeil, I need you to look in the camera while we're even if you're not testifying. Ms. Clarity, do you have questions? Go ahead and follow with questions of Mr. Stovall.
Thank you, Your Honor. Ms. Stovall, okay, you said there wasn't a 50-50 plan?
Right, yes.
Okay, but isn't it true that you all agreed, okay, he will pay $300 back in 2023, is that correct? You agreed to
Yes.
that?
Mhm.
Okay. So, but now you're claiming that you want retroactive for 900 something. Is that
Yes.
correct? So you're reneging on your agreement.
Yes.
Okay. You said you have lived at different places because you had to live with your grandmother.
Last
correct, in the past
this
year?
last couple months. Yes. No, I've
Okay.
only lived in one place, and that's that address that you have where I moved with my grandmother. That only place.
Okay. And isn't it true during that time, Jayla, the child was living with her father primarily because you didn't have a steady place of residence?
No, not at all. She's been there 100%. She's never stepped foot to spend a night at all.
Okay. Father's residence is listed on her driver's license. Is that correct?
Her driver's license, I have a picture of it. It is 1903 where I currently live now. It's never had his address on anything.
Okay. Is she registered to vote at your address, or isn't it true she's registered
Yes.
to vote at her father's address?
She's registered to vote at my address because she did vote and she worked for the polls then. So it's my address because she got paid for it as well.
Dad concedes 3 years with mom, 1 year with me, then describes a flexible ad hoc schedule, 2-3 nights when she feels like coming over, complicated by truck driving hours. That reads more like partial possession than primary custody. For support purposes, sporadic visits rarely erase primary home obligations unless it hits true 50-50. Engagement. If a teen with a car chooses where to crash based on convenience, should that shift child support? Or does support follow the consistent caregiver?
Objection, non-responsive to what she got paid, as he is, non-responsive. You said you've paid $357 a month for her medical insurance. Is that correct? Is that only for her? Is that for you and her?
No, that's her by herself. Together, we split it in half when we did the payment arrangements. It's $357 bi-weekly. So that's just for her, and we just split it.
Do you have any other children?
No.
Do you have, okay, you said vision, but you don't have any, what is it? Not vision, the other one,
Dental?
okay. Yeah, dental. You don't have dental, is that correct?
She does have dental. That's where most of her money goes, is her dental work.
Okay. And you're claiming that he should reimburse you the whole amount of $35,159 for retroactive, even though you all agreed to $300 back in 2023.
Yes.
Okay. I have no further questions.
Okay. All right, Ms. Nutt, call your next witness.
The state calls the father. Sir, will you state your name?
Jonathan McNeil.
And Mr. McNeil, when your daughter was born, did you sign a document admitting to paternity?
Yes, I did.
Okay. And in the last 4 years, who has your daughter been primarily living with?
3 years with her mom and 1 year with me.
And when was that 1 year with you?
It began in July to Karen.
Began in July of when?
July of 2024 to currently right now. We have documentation showing the school records with my address.
So, does your daughter spend 50% of her time with you and 50% of her time with the mother?
I don't know how much time she spent with her mother. I don't stay with her mother. I don't know how much time she spent with her mother. I just know about me. She spent times with me when we communicate to spend time with each other due to my work schedule. That's when we see each other.
So how often on average per week would you say she's sleeps over at your residence?
Maybe 2 or 3 times whenever she feels like coming over. Like I say, my daughter has a driver license. She has her own vehicle, and I work, and I'm a truck driver. So when she comes,
Dad disputes the $12,025 credit, says it could be more, and adds 110-month phone bills and other expenses. Here's the legal nuance. Non-court ordered extras, phones, cash, prom money, are frequently not automatic credits against support unless the order or statute allows it. Judges may award equitable credits for big traceable items. Think documented car purchase, fees, repairs, but they need receipts. Dad's best lane is to itemize and prove each dollar, not just ballpark thousands.
see me, we have never had no arrangements on the time that we spend.
In the last week, how many days did she come over?
I've seen her probably about 2 to 3 times. Like I said, she'll be here this evening.
And does she spend the night or does she just come over for a couple hours?
Yeah, she spends the night. She has her own bedroom here.
Okay. And then you and the mother had an agreement in 2023 where you paid her $300 a month.
Yes.
Okay. And we calculated that to give you credit for $12,025. Do you agree to that?
No, I don't.
And why not?
Because it should be more than that.
How much more?
I don't know. I had to go back and look at bank statements and all kinds of things, but there's various things that I pay for my daughter. Like I pay her monthly phone bill every month that I haven't got credit for.
Okay. How much is that?
That's $110 a month.
Under tight questioning, Dad admits no reimbursements for premiums, and he doesn't owe medical retro in his view. That admission, plus Mom's paper trail, tees up a likely medical judgment. Remember, a parent's knowledge of ongoing private coverage without sharing the cost often leads to repayment orders. Engagement, fair or not. If one parent voluntarily carries insurance for years without a court order, should the other parent be back-billed later?
All right. And so are you in agreement or disagreement with the $35,159 in retroactive child support?
Disagreement.
Okay. And do you think the retroactive child support should be zero, or do you think it should just be a lower amount?
It should be a lower amount. It should be. I mean, if we agree to $300 a month from 2023, Ms. Stovall signs off on the document saying that she did not want no child support obligations in January of 2023. My attorney has the paperwork. So from January 2023 to now you got to give me credit also for the year that she's been staying with me, because I got proof that she's been staying with me, voter registration card registered to my address, school records registered to my address from August. So therefore, we're talking about maybe a year that we agreed on the 300. Did I give her 300 from January 2023 to July of 2024? Yes, I did. And that was our agreement.
Okay. And do you understand that even if her voter registration card is at your address, that's not proof that she lives primarily with you?
There's no proof that she lives primarily anywhere.
I have proof.
Okay. Sir, you heard Ms. Stovall say she's requesting reimbursement for the private health insurance that she's paid the last 4 years, correct?
She's already accepted an agreement. We had an agreement.
Objection, non-responsive.
Sustained.
And sir, did you know Ms. Stovall was providing private health insurance these last 4 years?
She's always provided private insurance for the last 18 years.
Okay. And have
So
you ever
there's nothing new.
reimbursed her for any premiums she's incurred?
Yeah, the agreement was that I financially would help.
Objection, non-responsive.
Sustain.
You're asking me a question. You gonna allow me to answer?
I just needed you to answer yes or no if you've provided her any reimbursement for the medical insurance premiums.
That was not part of the agreement. For
Objection,
me
non-responsive.
The yes or no question is what she's asking you, Mr. McNeil. So she wants your answer, but you're just trying to explain it. So either say yes or no to the question.
No.
Okay. And she's been paying $357 per month for your daughter's coverage, and so that in the last 4 years totals up to $17,136, and we're requesting you pay that back at $136 a month. Do you agree or disagree with that?
Disagree.
And do you think you owe any retroactive medical support, or you just think it should be a lower amount?
I don't owe no medical support.
Watch the calculation. The judge honors the $300 private deal across 48 months, $1,400. Subtracts dad's recognized credits, 12 eyes 25, leaving about $2,375. Then effectively wipes it considering other documented expenses dad paid. Translation. In a first-time support case with no prior order, this judge respects a stable, mutual arrangement even if the guideline would be $983 a month. Key takeaway. Courts can temper rigid math with equity when both sides behaved in good faith, and the child was supported in practice.
Okay. And do you understand that this agreement you're referencing was never filed with the court and it's not a court order that is valid?
I don't need no court order.
Okay. I'll pass the witness.
Okay. Miss Clarity, go ahead.
Mr. McNeil, true, your daughter's already turned 18, is that correct?
Yes.
And she graduates in a couple of weeks?
Yes.
Okay, and she's been living with you primarily this past year?
Yes.
Okay, and it is also true you and Miss Stovall had no agreement regarding any possession in the past 4 years other than the child support. Is that correct?
What you said?
Well, you didn't have any agreement regarding where she would live in the
No.
past 4 years. Okay. And so is it true that she stayed with you part-time in the past 4 years and stayed with her part-time?
Yes.
Okay. And is it true, the only thing you're admitting is that she's been paying the medical insurance, is that correct?
Yes, that's what we agreed to.
And did she ever ask you or request or file anything asking you to pay her, reimburse her for that?
No.
Have you had any health insurance for your daughter in the past 4 years?
No.
Okay. Do you have it available to you?
Yes.
Through your truck driver? Okay. Do you have other children?
No.
Do you have any children over the age of 18?
Yes.
Yeah. Do you have any children under the age of 18?
No.
Okay. All your children has turned at least 18?
Yes.
Okay. Now, you indicated you were not in agreement with the amount of the $35,059 that was calculated by the Attorney General's office, $983 a month. Is that goes against what you had previously agreed to pay, $300 a month beginning back in January 2023. Is that correct?
Yes.
So you would ask the court to honor that agreement?
Yes.
Okay. And calculate it based at that $300 per month up through the current time. Is that correct?
Not the current time. I would ask that it stop when the school records start showing that she's at my address this year.
And that was as of July 2024. Is that correct?
We'll just say August when school started, August the 20th when school started.
Okay. And so do you have an amount that you should have to pay, or that she should have to pay you for that matter, since there was no previous order?
Correct. Yes.
Okay. Is there anything else you want the court to know?
Yes,
First, what
ma'am.
are the expenses you paid for your daughter?
Yes, I have documentation showing that I paid senior fees. I have paid driver license fees for my daughter to get her driver license. I have also paid for her to get a vehicle that she's currently transporting in right now. I have all the documentation that shows that I was the person. I transferred the title to the vehicle over to Miss Stovall.
Okay, and when was that?
March of 2024, last year.
Okay. And with respect to the senior fees, the driver's license fees, and the vehicle, you had vehicle repairs, right?
Yes.
You pay. Any idea how much you paid for that?
Oh man. Oh man. Nah, thousands of
Any
dollars.
estimate?
Between $3,000 to $5,000. I know for sure.
And what about the senior fees?
That was $500, I think. And I just gave money for prom. I gave my daughter money, visually cash money all the time. All the time.
And the driver's license fees?
I paid $500 for her to get a driver's license for the driving school.
She had to go to driving school. Okay.
Yes.
So altogether, if you add that, that's was three to 5,000 for vehicles. So we're gonna calculate that about 5,000 that you paid solely on behalf of your daughter that
Yes.
you're asking credit for. Is that correct?
Yes.
Okay. Is there anything else?
No, I just took her to Grambling on a college tour, which the school she's planning to attend in August. I paid for that too.
Okay. And
I
you'll be
paid.
paying some college expense, even
Yes.
though that's not an issue for today.
He said no.
Objection to what Ms. Stovall said. She's not testifying, Your Honor.
Sustained. Mr. Owa, no one's asking you any questions. Mr. McNeil is the one answering questions right now.
Okay.
Okay, Mr. McNeil, you want to answer the question, or do you need her to repeat it?
Repeat the question, please, John. Miss Claudia, please.
No, I said you plan to continue to support her for college. Is that correct?
Yes, ma'am, I do.
Okay. I have no further questions.
Okay. Does the state rest? You're muted, Ms. Nutt.
Sorry, yes, Your Honor.
All right, Ms. Clarity, do you rest?
Yes, Your Honor, I do have a closing statement, though.
Go ahead.
Okay. Your Honor, I believe based on the evidence, first of all, this is a child who's already turned 18. There's been no orders in effect for the past 18 years other than the fact that my client agreed to pay $300 a month back as of January 2023. I think that agreement needs to be honored. To assess him $983 goes against what the testimony was and everything. 35,159 is not a fair and equitable amount for retroactive child support. Again, these parents must have been doing something right if they've been able to work together all this time, and here at the nth hour, we have a motion that was filed just this past month. I think father needs to be given credit for all the payments he's made, as well as the extra fees. I think we all know that senior year is always an expensive year for high school students. That needs to be taken into consideration. So, Your Honor, that's what we asked for. We asked you to deny the request for the 35,159 and make adjustments for the health insurance, the retroactive health insurance. Thank you, Your Honor.
Okay,
And
thank you.
I do have a response to that.
Yes, ma'am.
We did give credit to the father for $12,025, which is part of the agreement that he and Miss Stovall made together. The state is not under the assumption that the child being registered to vote or just being enrolled in the father's school address means she lived primarily with him. And so we are requesting the retroactive child support for the full last 4 years. Additionally, the father knew that Ms. Stovall had private insurance, but did not provide any support to help cover those premiums. And so we're requesting those be reimbursed for the last 4 years as well.
Okay. All right. The easy one, of course, I'm not going to order child support for the future. So I'm not going to order child support for June 1st, since that'll be pretty much like 2-3 weeks from now. That probably doesn't make sense. So, as far as the other issues, I'm doubt that y'all probably had legal counsel when y'all arranged the $300 payment, but it's something that y'all had set up under the circumstances of what both of your incomes were and what the expenses were and things like that. I usually try to honor those, especially if we're here on a first case. Like, this is the first time we've ever talked about child support. We haven't done any prior court orders. So for some reason, y'all agreed to $300. Now, I mean, looking back now, I guess in retrospect, it probably should have been about $983, maybe, but that's the number y'all agreed to. And so if I look at it that way, $300 times 48 months would be $14,400. And I subtract $12,025, that leaves us with a balance of $2,375. And then if I'm going to halfway believe Mr. McNeil paid some other expenses, that pretty much wipes out that. Okay, so I'm just going to say that as far as child support is concerned, Mr. McNeil does not owe any retroactive child support. So there'll be a zero balance for that.
Ruling. Retro child support. $0 after credits and equitable considerations. Retro medical. $15,000. Payable 150 months starting June 1st until paid, with the option to pay faster. The lesson? If you rely on a private payment plan, keep receipts and consistency. It can persuade a judge, especially in a first order. But medical costs? Courts expect shared responsibility, and clean documentation wins the day. If you found this case as shocking as we did, smash like, drop your verdict in the comments. Was honoring the $300 deal the right move? And subscribe for more jaw-dropping courtroom breakdowns. New cases every week. Don't miss the next twist.
Now, medical, definitely there's medical due and owing. Obviously, Mr. McNeil admitted he does not have the child on his insurance for health, dental, or vision. Ms. Stovall, you have. So I am entering a judgment for medical, since that was not part of this here, that arrangement of the $300. That was something additional. So I'm ordering a judgment for retroactive medical in the amount of $15,000 to be paid at $150 a month until paid in full. So the only thing that will be due just is the medical part.
For that $15,000 even, Your Honor?
Yes, ma'am.
Okay, 150 payout.
Yes, ma'am.
Beginning
June 1st. And he can always pay more, but just trying to set it at a low payment, and then he has the option to send in more or pay it all off, however he chooses. But at the minimum, he needs to pay $150 a month. Okay. Court cost builder, Mr. McNeil. And that should wrap your case up. So once the last payment is made of the $15,000, then the case can be closed with the Attorney General's office.
This ruling shines a spotlight on a deeper truth. In family court, it isn't always about cold math. It's about credibility, records, and balance. Dad's informal $300 deal held weight, but Mom's clean documentation on medical coverage proved undeniable. In real life, plenty of parents operate on handshake agreements until conflict brings them to court. That's when the paper trail, or lack of it, decides thousands. So here's my challenge for you. Do you think judges should always enforce guideline support or honor private agreements if both parents relied on them? Your opinion might surprise you. Drop it in the comments.
So however long that takes to pay that off. All right, that's my ruling. The Attorney General's office is going to draft that. And Ms. McClary, did you want to see the order or?
Yes, I do, Your Honor.
Okay, all right. Ms. Dodd, do you need any information from Ms. Clarity, email address or anything?
I filed the answer and everything, so they should have all that.
Okay,
Correct, Your Honor.
okay, perfect. Okay, then they'll be sending you a proposal order. That'll be the order of the court. All right, y'all are done and are excused. You can press leave on the Zoom to exit out. Thank you.
Thank you, Your Honor.
Thank you.